All right, welcome to this explainer. Today we're going to dive into a massive constitutional court showdown. We're looking at a fascinating case that asks a really fundamental question about how our legal system works. We are going to see exactly how one man's hit-and-run car crash basically exposed a deeply flawed, rigid bureaucratic system. And as you'll see, the actual collision was really just the beginning of the fight.
So, let me ask you a question. If you're the victim of a hit-and-run, does a seemingly mundane administrative technicality really have the power to lock you out of the justice system forever? I mean, it sounds absolutely absurd, right? You get injured, you're just trying to recover, and yet a ticking clock on a random piece of government paperwork might dictate whether or not you get the protection that the law literally promises you.
To understand how the Constitutional Court weighs government regulations against human rights, let's take a step back to February 22, 2002. This is on a dirt road between Clanwilliam and Citrusdal in South Africa. Mr. Reinier Engelbrecht was driving his vehicle when, out of nowhere, he was struck by a truck. And the truck didn't stop, it just fled the scene, leaving Mr. Engelbrecht injured and completely unable to identify the driver or the owner of the vehicle.
Now, the timeline of events here is absolutely crucial. On February 22nd, the collision happens, and Mr. Engelbrecht is hospitalized for a few days. By March 5th, his doctor actually considers him medically fit to return to work, but here is the catch. He only managed to physically submit his affidavit detailing the accident to the police on May 4th. Keep that gap between early March and early May in the back of your mind.
So, because the truck driver took off, Mr. Engelbrecht had to seek compensation from the Road Accident Fund. Now, if you aren't familiar, this is a massive statutory body established under Act 56 of 1996. Its entire purpose is to protect South African road users and pay compensation for losses wrongfully and negligently caused by motor vehicles. It's essentially a giant insurance net designed for exactly this kind of worst-case scenario.
Mr. Engelbrecht files his lawsuit against the fund claiming a very specific amount, just over 214,000 rand for the injuries he sustained. And the litigation was moving forward, but right before the trial actually started in the High Court, the fund dropped a devastating legal maneuver. They introduced a special plea, which is essentially a legal loophole used to block the entire payout and get the case thrown out before the actual facts were even argued.
The fund basically turned around and argued they owed him absolutely nothing. And not because he wasn't injured, and not because the accident didn't happen, but because he fell into a bureaucratic trap hidden deep within the regulations made by the Minister of Transport. They pointed specifically to this tiny little clause, Regulation 21C.
Regulation 21C is uncompromising. It states that the fund is not liable to pay a single cent unless the victim submitted an affidavit to the police fully setting out the particulars of the occurrence within exactly 14 days of being in a position to do so. Now remember our timeline? Mr. Engelbrecht filed on May 4th, which was way over 14 days after his release from the hospital in early March. He missed the deadline.
This sets up a massive legal showdown. On one side, you have the Road Accident Fund standing firmly behind a super rigid 14-day administrative rule. On the other side, you've got Mr. Engelbrecht wielding Section 34 of the Constitution, which guarantees everyone the fundamental right to have a dispute decided in a fair public hearing before a court. So the question becomes, can a minister's regulation completely override a constitutional right?
Now, Mr. Engelbrecht faced an enormous legal roadblock, and initially, he actually lost in the High Court. The High Court upheld the fund's special plea and dismissed his claim entirely. Why? Well, because the courts had recently ruled against claimants in his exact position. The legal precedent was simply not on his side.
The Supreme Court of Appeal had previously decided in a very similar case, a case called Makwetlanhe, that hit-and-run victims didn't historically have an enforceable claim under common law. Think about this catch-22 for a second. Because you couldn't identify the driver who hit you, you theoretically had no one to sue. Therefore, the lower courts reasoned Section 34 of the Constitution didn't even apply to them, because the failure to meet the 14-day deadline meant a valid legal claim never even came into existence in the first place.
But Mr. Engelbrecht wasn't giving up. He appealed directly to the Constitutional Court, and they fundamentally disagreed with the Supreme Court of Appeal. The Constitutional Court invoked this incredibly powerful ancient legal principle to visualize the invisible rights of citizens. Ubi jus, ibi remedium. Where there is a right, there is a remedy. They stated that at common law, you absolutely have a right not to be injured unlawfully and culpably by anyone, and that includes an unidentified truck driver.
To make their point, the Constitutional Court actually looked way back to older case law from Justice Watermeyer. They declared that in negligence cases, a legally enforceable claim comes into existence the very second the victim suffers a wrongful injury and incurs damage. The right to sue is literally born at the moment of impact. Sure, the fact that the driver is unknown might make it hard to enforce practically, but the right itself definitely exists. Therefore, Section 34 of the Constitution absolutely applies.
Okay, so winning the right to sue was huge, but it was really only half the battle. Next, the court had to ask, was the 14-day rule a justifiable limitation of that right? Because as we know, constitutional rights aren't always absolute. They can be limited, but only if the limitation is reasonable and justifiable in an open and democratic society under Section 36 of the Constitution.
To figure this out, they didn't just guess. Let's walk through this specific checklist to see exactly how the constitutional judges impartially weighed the government's regulations against constitutional freedoms. They had to look at how important the right is, why the government is limiting it, how severe that limit actually is, whether the limit even works, and if there's a less damaging way to achieve the government's goal. Now, playing devil's advocate for a second, the Minister of Transport forcefully defended the 14-day law. They argued it was absolutely necessary to combat fraudulent claims. And honestly, you can kind of see their point. Without a strict timeline, it's very easy for someone who, say, crashed their own car into a tree to just lie and say a phantom truck ran them off the road. The government argued they desperately needed swift police reports to investigate and stop fraud in its tracks.
Furthermore, the government argued the rule wasn't even that strict. They pointed out what they called two double qualifications built right into the text. The clock only started if reasonably possible and when the victim was in a position to do so. They argued this built-in flexibility delayed the 14-day clock if a claimant was hospitalized, physically incapacitated, or even trapped by floods. They claimed this flexibility saved the rule from being unconstitutional.
All right, so here is the million-dollar question. How did the Constitutional Court rule when balancing the government's need to prevent fraud against the citizen's fundamental right to access the courts? Did those 14 days actually offer a real, fair opportunity for justice?
Writing for a unanimous court, Justice Condyle delivered a pretty gripping climax to this legal battle. The court found that 14 days is not just short, it is palpably unfair. Justice Condyle pointed out that the vast majority of citizens are completely unaware of this obscure regulation. To expect someone, particularly the illiterate and the poor who might not have immediate access to legal counsel, to magically know about and meet a 14-day deadline after a traumatic accident effectively nullifies their entrenched right to court access.
The court then systematically dismantled the government's defense. First off, 14 days was just too short for fair access. Second, and this was a massive blow, there was literally zero evidence that the police or the fund actually used these rapid affidavits to investigate fraud anyway. The government tried to blame police understaffing, but the court flatly rejected that excuse, stating that administrative understaffing does not justify stripping citizens of their constitutional rights. The grave harm done by the rule far outweighed any perceived benefit.
So, in a landmark resolution, the Constitutional Court struck down the 14-day rule entirely. They declared Regulation 2(1)(c) inconsistent with the Constitution and invalid. They didn't just suspend it, they severed it completely. It really proved that even a massive bureaucracy with totally understandable goals, like preventing fraud, must still bow to the supremacy of the Constitution. Mr. Engelbrecht's case was sent right back to the High Court for his claim to finally be heard on its actual merits. Which leaves us with a truly fascinating question to chew on as we wrap up. If this mundane, highly specific administrative rule couldn't survive constitutional scrutiny because it unknowingly trampled on access to justice, what other seemingly unshakable government regulations are vulnerable right now? I mean, how many bureaucratic traps are hiding in plain sight, just waiting for the right person to stand up and challenge them? Thank you so much for joining me for this explainer, and keep questioning the rules around you.